United Nations independent expert on combating impunity, is that the court has had, in fact, quite an extraordinary impact in strengthening domestic processes of accountability. Judge Kirsch mentioned briefly in his remarks that the court has been a catalyst for national legislation. What he was referring to is that states parties to the Rome Statute have enacted laws to empower their own courts to exercise jurisdiction over international crimes. And these changes in national law, coupled with the prospect of a viable court being available to prosecute atrocious crimes, has provided new energy to national systems. Victims have a new set of weapons, legal weapons, at home. And in response to their obligations as state parties, many states have torn down seemingly impregnable barriers to prosecution. And so it's a mistake to see the court as disempowering national sovereigns, but rather its effect, as well as its intent, has been to strengthen justice at home.
Thank you, Diane. We've heard so far two very enriching and differing views on the court. Let's see what Michael has to add to this.
Thank you very much. I'd like to focus in my introductory comments on the relationship between the United States on the one hand and the International Court and its supporters on the other. On the one hand, I can well understand and appreciate the desire of the U.S. government to conduct its own investigations and, if necessary, its own prosecution of U.S. military or civilian personnel who may be accused of committing international crimes. I think in practice it probably will be infrequent that the International Criminal Court will actually have American citizens before it, but I can understand that there are some questions about the application of the principle of complementarity, which would raise legitimate concerns on the part of the U.S. government. I think it's also the case that it's very unlikely, at least for the present, that the United States is going to ratify the statute of the court or begin extradition of persons in the United States to the court. I don't happen to agree with the constitutional arguments that Mr. Rifkin has just made, but it is nonetheless true that these things would require action by the Congress, and I think it's probably, as a practical matter, not likely that this is going to happen anytime soon. Perhaps at some later time when the court has established a track record of responsible action and effective action, perhaps these issues could be reconsidered then, but not for the present. On the other hand, it seems to me that notwithstanding all that it would be wrong for the United States to adopt a policy of outright hostility or across-the-board non-cooperation with the court, particularly in cases where U.S. personnel are not involved. It seems to me that the United States and the court have strong mutual interests in a cooperative rather than an antagonistic relationship. From the point of view of the International Court, there are a number of reasons why it would benefit greatly from having a cooperative relationship with the United States, including the fact that the Security Council will only act in favor of the court if the United States is prepared to support or acquiesce in such action. First of all, as you have already heard, there are definite limits in the statute of the court on the jurisdiction of the court. In particular, the fact that the court can only exercise jurisdiction over crimes where the crime is committed in the territory or by a national of a state which has adhered to the statute of the court. However, the Security Council can obviate these limitations by acting to refer a case to the court, even if it's otherwise not within its jurisdiction. Secondly, the Security Council can impose obligations on states which are not party to the statute of the court to cooperate with the court in various ways, including by providing evidence and extraditing individuals who are accused of crimes. This could be important for the court. We see this in the case of Sudan already. Thirdly, I guess, in the case of the ad hoc tribunals, the United States has provided important assistance bilaterally to the tribunals, including providing intelligence, providing personnel, providing services and finances. and it may be that the International Court will benefit in future years from such assistance if the U.S. is prepared to give it. Fourthly, it has been important with respect to the international ad hoc tribunals for Yugoslavia and Rwanda for the United States and other important states to be prepared to apply political and economic pressure upon non-cooperating states. And it may be that this will be important in some cases in the future of the International Court as well. From the point of view of the United States government, I also think that the U.S. has some important reasons why it would want to have a cooperative rather than an antagonistic relationship with the court. First of all, there may well be cases where the United States wants to have international prosecution for crimes, and yet the only practical alternative for this would be the ICC. Cases where national authorities are unable or unwilling to prosecute, where the Security Council would be unwilling to create additional ad hoc tribunals, and in fact we have such a case before us right now in the context of Sudan. Secondly, it seems to me that the U.S., through a cooperative relationship with the court, can better protect its own national interests in the court's proceedings, particularly with respect to the possible prosecution of American personnel. Thirdly, it seems to me that a cooperative relationship, rather than an antagonistic one, will better serve the U.S. interests with respect to its relations with key allies, with respect to its interest in the operations of the United Nations, particularly peacekeeping operations. What do I mean by a cooperative relationship on the part of these two actors? From the point of view of the United States, it seems to me that the U.S. should be prepared in appropriate cases to support the referral by the Security Council of categories of crimes or situations for prosecution, even though the court otherwise does not have jurisdiction. It seems to me that this kind of referral by the Security Council is in fact consistent with the U.S. policy with respect to the creation of the ad hoc tribunals, both of which were created by action of the Security Council and which otherwise would have had no jurisdiction whatsoever. And I might add, in both cases, this jurisdiction was imposed notwithstanding the fact that some of the states involved did not consent to the application of that jurisdiction. It also seems to me that the U.S. should not attempt to penalize other states which desire to adhere to the jurisdiction of the court. It seems to me that the United States should not sacrifice important relationships with other countries, including military assistance relationships, nor should it sacrifice peacekeeping operations that are consistent with the United States merely to make the point that it has disagreements with the court. From the point of view of the International Court and its supporters, a cooperative relationship, I think, would require that the court give due regard to the interests of the United States in the conduct of its own proceedings, particularly with respect to possible prosecution of American personnel. It seems to me that the supporters of the court should be open in appropriate cases to the adoption of alternative means of prosecution where that seems to be the most practical alternative. That might be acceptance of a hybrid tribunal. It might be granting additional jurisdiction to one of the ad hoc tribunals. I think the current case of Sudan is a very good example of a situation in which decisions about international prosecution should be made on the basis of what solution will most effectively bring about effective prosecutions, as opposed to making a decision on the basis of one's political views about the court or one's ideological antagonisms. I understand from the press reports today that the United States has now dropped its objection to the referral by the Security Council of the Sudanese situation to the International Court. Hypothetically, the Council might have created a separate ad hoc tribunal for this purpose, perhaps located in Africa, perhaps drawing upon the resources of the current ad hoc tribunal for Rwanda. I don't know which of those two solutions would have turned out to be the most effective. What I do know is that the decision should be based on what would produce the most effective prosecution rather than on some overall political or ideological differences about the court as a whole. Thank you.
Thank you very much, Michael, for this very interesting perspective. And finally, we'll give the floor to Mr. Claire Roberts from the Inter-American Commission on Human Rights. Please, Mr. Roberts.
Thank you very much, Irene. The Commission, being part of the OAS family, I'm very pleased to join in welcoming the President of the International Criminal Court and the other distinguished members of this panel to the Organization of American States, and for the opportunity to provide some brief comments on the ICC and the enforcement of international justice from the perspective of the inter-American human rights system. And so I will attempt to widen the discussion even further. I would like to begin by noting that although the Commission and the ICC are both international treaty bodies with adjudicative responsibilities, their roles are nevertheless distinct. Most importantly, while the Commission is charged with determining state responsibility for violations of the rights under the American Convention on Human Rights and other applicable human rights instruments, the ICC has the mandate of determining individual criminal responsibility for the most serious crimes of international concern as prescribed under the Rome Statute. This does not mean, however, that the functions and mandates of the two institutions are unrelated. Substantively, the ICC and the Commission are concerned in their work with many of the same atrocities under international law. In this respect, numerous crimes falling within the ICC's jurisdiction, such as crimes against humanity and war crimes, also encompass, by their nature and by definition, serious violations of human rights falling within the competence of the Commission, such as torture and forced disappearances. Procedurally, the competence of both bodies is complementary to national jurisdictions, in the sense that the Commission and the ICC will generally act only when national authorities are unwilling or unable to remedy serious human rights violations. In this way, both bodies serve to encourage the effective protection of human rights at the domestic level. Indeed, the subsidiary nature of the Commission and the principle of complementarity enshrined in the Rome Statute both make clear